His Lordship the Chief Justice, Dr. Pratibha Mahanama, Dean of the Law Faculty, Mr. S.L. Gunasekara, Mr. Asoka De Silva, Dr. Asoka De Silva, Mr. Govind Das, ladies and gentlemen, I'm indeed privileged to be invited to address you on this occasion, and the topic that has been given to me is social justice and the law. I think this is an aspect that was touched upon by His Lordship in His Lordship address to you. But I must also tell you that I should congratulate the organizers of this symposium for the selection of the topic, because that is something that all of us should focus attention upon. Social justice and the law is not a topic that came up recently, because even during ancient times this was a matter that was considered most important. Now, if you take the English law was based on the English common law. And when the English common law did not offer any solution to the problems of the people, then the question of equitable solutions came up. And the Chancery Division was established for the purpose of giving equitable solutions to problems where the common law did not offer any sort of solution. I think this is the commencement of equity, and this is the commencement of social justice and equity as well. This, I say, is extremely important, is because as we go on enforcing the law, we should always have in mind that the ultimate beneficiaries of all the reforms, all the steps that are taken within the legal framework should be the people of the country. So all law reforms, all laws, interpretations, everything should be aimed at, designed to give the people the ultimate benefit of the legal system that prevails. So equity and social justice arises as a result of that. What is the use of any law if the people of a country do not derive the benefit of it? I'm sure all of you, the law students who are here, must be aware of the famous case of Donoghue versus Stevenson. Anyone who is not aware of the case of Donoghue versus Stevenson? Law students? All are aware of the case of Donoghue versus Stevenson. I think it is absolutely necessary that we touch upon this, because Donoghue versus Stevenson is a case in which the English law was extended to say that you owe a duty of care towards your neighbor. Now that was a case, as you know, where two persons went and enjoyed a bottle of ginger beer, and then having consumed half of the bottle of ginger beer, when they poured the rest also into the empty glasses, they found that a decomposed snail, the remains of a decomposed snail also fell into the glass. And when action was filed against the manufacturer of ginger beer, the manufacturer said that we have nothing to do with them, because they were not our neighbors and we did not have any sort of duty of care towards them. It was in that case that the concept of neighbor was extended by the English law to mean anyone who comes in contact with you as a result of your activities. Now that shows an important milestone, an important step in the progress of English law, where it was brought into play within the system of social equity. Now social equity, as you know, sometimes does not come into operation because sometimes the law is enforced in an extremely rigid manner. If the law is enforced in a rigid manner without taking into consideration the people to whom the law applies, the impact upon society, then social justice and equity will be wanting in a system like that. And I think it is one of the reasons why they have thought of this very important topic, social justice and equity, in the system of law. Because we cannot think of a system of law which is devoid of that impact upon society, the impact upon the people, impact upon the institutions which enforce the legal system. Now, before I came here, or a little while ago before I came here, I was talking to some of the other speakers, and then I told them that one of the most important things that we should concentrate upon in the enforcement of law is that the law must be accessible to the people. If the law is not accessible, if the law is far away from the people, if litigation is too expensive, if people haven't got the confidence of accessibility, I think that is a serious lapse that we have to take into consideration the enforcement of the law. Now, sometimes the allegation that has been made against law enforcement in this country is that litigation is extremely expensive. People who sometimes think that they have a good case where they can go before the court of law and have it enforced do not want to enter into litigation because of the time lapse which they think is something that acts as a deterrent for them to go before the law and have the legal principles enforced in their favor. Now, this is something that we should avoid as much as possible. I think His Lordship, the Chief Justice, when he was speaking on this, he mentioned that litigation cannot be expensive. Litigation should be expeditious as well. If litigation is not expeditious, it's not expeditious. If litigation is going to take a long time, now as His Lordship mentioned, if a case is going to take 25 years and if it is going to go down generations, if it cannot be concluded within one generation, if the case that you have commenced ends when your great-grandson is a party to that action, then the law has not achieved the objective the law has to achieve. And that is why we see that we must now think of a situation, we must now think of a system where law can be enforced for the purpose of enforcing social justice and equity. Now, it is for this reason that we have now thought of systems, alternate systems of dispute resolution outside the legal system. A court of law is a place where you go into a formal procedure. You have to adhere to a particular formal procedure, and within the court of law, there are certain rules of evidence you have to comply with, you have to adhere to. As a result of that, the people do not get the benefit of an expeditious trial. So we have to think of all these, and as a result of that, we have now thought of dispute resolutions outside the system. For example, things like arbitration. Now, arbitration or mediation, conciliation, all those things are rules or institutions which enforce the law outside the normal, traditional, the courthouse system. Now, these are some things that we have to look upon because we find that the court system has found itself incapable or impotent in enforcing the law to the satisfaction of the people. If that message goes down, then what happens next is that the people will take the law into their own hands. And if the people take the law into their own hands and think of enforcing it themselves, then it will be a situation which will lead to disaster. Now, that is something we have to avoid, and that is what we can avoid by making the law closer to the people, accessible to the people. Enforce the law in a way that social justice and equity gets the important place that it deserves. Attention must be drawn to that fact of the people, of those who enforce the law, to tell them that if the law is not enforced in a way which brings social justice into play, then one of the major objectives of the law is not achieved. Now, in India, there was a system called the epistorial jurisdiction. Epistorial jurisdiction was where a person found that there was a problem which bothers him, in which he thinks that he could have a solution according to the law. All that he has to do is write a letter to the Chief Justice of the country. Justice Bhagavati brought that system. Outside the rigid methods of legal procedure, you write a letter to the Chief Justice, Justice Bhagavati of India, and then from that point on, the Supreme Court takes upon itself to enforce the law in order to give some sort of relief for the person who is seeking relief. I was relating to a story to Lakshmini and also Dr. Ashoka De Silva some time ago, where a person had written a letter to the Attorney General. And then in that letter, there was a young lady. She had said that I have a problem and I don't get relief from law. And what she was asking was whether there was a possibility of helping that person. Now, this was a case where she had given a necklace to a friend, and the friend wanted to wear the necklace for a wedding and then return it, but then the necklace was not returned. When the necklace was not returned, she went to the police and made a complaint. The complaint was recorded. The necklace was traced. It had been pawned. And thereafter, the court proceedings commenced. After the court proceedings commenced, it was told that this lady, the accused, absconded. So this lady tolerated this for a long time. And ultimately wrote to the Attorney General and said, my necklace was recovered by the police. The police has now produced it in the court of law as a production. The lady is absconding. The case is being postponed every day. I've gone to court for 1.5 years. Still I have not got my necklace. She says, I'm not bothered whether that lady is sentenced or not. Please give my necklace, that is all I want. Now, ladies and gentlemen, that is a simple solution. The solution is very simple. The solution is where you file a motion in court and then tell the judge of this difficulty, and where the judge gives an order releasing the necklace to that lady. Under normal circumstances, the necklace is brought to court and kept sealed for the purpose of going through the whole case and then giving it to the lady. Now, that is where the law should come out and try to enforce the law in order to achieve social justice and equity. That is where you should be away from these rigid rules. Enforcement of the law should be according to the wishes of the people. And once one great judge had once said that the law should be what the people want. The law should give the solutions or the relief that the people want. And if the people cannot get that relief through the legal procedures, and if the legal procedures are too rigid, and the people have no remedy, then there is something wrong with that law, and the law can be described as an archaic law. Now, His Lordship, the Chief Justice, referred to the Supreme Court and said that the Supreme Court has fundamental rights jurisdiction. Now, in terms of fundamental rights jurisdiction, if a person is tortured, the law, sir, is that that person should come to court himself, or an attorney at law on behalf of that person should come to law. Now, that is what the law says. But then it has been interpreted by the Supreme Court now by saying, no, we can go forward and even the wife of that person can come to court. Now, there was a particular case where that person was assaulted and he died. According to the provisions of the Constitution, the person is dead and no lawyer came forward, then there is no remedy. But then with a judicial interpretation, with extension of the judicial interpretation, they said in a situation like that, even the wife is entitled to come forward in order to file the fundamental rights application in order to get the relief before the Supreme Court. So these are things that we have to give our mind to. Ladies and gentlemen, you, I hope, will be attorneys at law very soon. After completing your legal degree, you will enter law college, hopefully, or pass through the law college and become attorneys at law. Once you become attorneys at law, one thing that you should keep in mind is that if you try to be away from the people, if you forget that the law must be enforced for the benefit of the people, that the people want some relief in terms of the law, and if that relief is not forthcoming, and if you try to be away from it, then the law is not worth the piece of paper on which it is printed. And that is why this symposium has been now organized. That is why Dr. Pratibhaba Mahanama had thought it important to discuss this very important topic with you. And I must also congratulate him on the invitation that has been extended to the panel. Mr. Govind Dayasri, Mr. Michel De Silva, Dr. Asoka De Silva, the Chief Justice himself, and of course myself as the Attorney General, because I think you cannot think of a better panel to discuss this matter and also to focus attention upon this matter. So with those words, and as we are now behind schedule already, I shall conclude, but then inviting you to ask whatever questions that you wish to ask during the period of discussion. Thank you very much.